The pandemic has created yet one more thing employers have to worry about. This is the IssuesWatch podcast. Hi, I'm Don Meyer, Chief Marketing Officer of the New Jersey Society of CPAs, and your guest host for episode 65. As businesses continue to reopen amid the pandemic, a significant challenge persists for employers, preventing wage and hour violations. Compliance efforts will be under scrutiny, and the impact of any mistakes will be magnified. Even before the pandemic hit, employers saw the enactment of numerous laws that dramatically upped the penalties for wage and hour violations. The NJCPA and the business community in general opposed these measures as they moved through the legislature. Here to talk about the biggest wage and hour mistakes employers should avoid is Kathleen Caminiti, a partner at Fisher Phillips, a national labor and employment firm representing employers. She is the co-chair of the firm's wage and hour and pay equity practice groups. Welcome, Kathy.
Very nice to meet you, Don. I really enjoy working with the New Jersey CPA community, and the topic of remote work and the wage and hour issues that it raises can't be overstated. And frankly, in New Jersey, as we'll talk about today, the wage and hour compliance issues really need to be top of mind for the CPA community and the law community. So I'm really grateful for the opportunity to have this conversation with you.
Yeah, this seems like one of those issues that CPAs or attorneys or professionals in general don't talk about until maybe it's too late.
Well, I've said many times that, attorneys and CPAs are their clients' trusted advisors. And, sometimes we're in a position to try to help them work out knotty issues. And sometimes the best advice we can give them is compliance issues. How to make sure that their house is in order so that they're complying with the laws, whether it's a tax law or an employment law, so that their businesses, as business owners, CPAs, many have their own firms, whether they're big or small, and their clients are well positioned to handle an audit, to handle litigation, to avoid both audit and litigation. So I agree with you. We are trusted advisors, and very often the question comes up in a situation where you're involved in an audit or there's trouble brewing, and so it's really nice to be able to have this conversation today when we're addressing issues proactively.
Right, exactly. And we know in New Jersey, compliance is always a challenge, always an issue, but why is wage and hour reporting particularly troublesome during the pandemic?
Well, really, there's a couple of different issues that are driving it. First, changing work environment. Folks aren't in the office during normal situation where maybe you work 9 to 5:30 with a half hour of lunch. People's comings and goings are kind of in a rhythm. That people are used to recording their time accordingly. With the pandemic, we were all forced to work remotely immediately, and that came with challenges in terms of flexibility. I mean, some people have children that they're remote learning as well. So they may need to take some time to assist with educational activities, or they may be sharing a computer. So there's flexibility that has arisen. Other issues are longer hours. You hear anecdotally that people say, we're always working, and part of that is it's omnipresent. You could just walk down the hall and your computer's there. So some people will check an email. Some people will stay the extra time because they're, not, they don't have a commute. But the issues really come up is that non-exempt people who are paid hourly, minimum wage, and overtime, you need to record that time, and they must be paid for all time work. So in the pandemic, the issues became just the change of what the new normal is, but the need to record that time and make sure that you're recording it accurately, and address things like the flexibility in terms of work schedules, and make sure that people are recording all their time worked, even if it's beyond what's authorized.
And we know another big issue in New Jersey is penalties when you do something wrong. So what kind of penalties can an employer be looking at if they violate wage and hour regulations?
Well, the penalties in New Jersey, Don, are more extensive than any other state in the country. August of 2019, the Wage Theft Act was enacted by New Jersey, which significantly enhanced penalties that were available for non-compliance. So there is a treble damages. If there's money owed, 200% on top of the money owed is added as liquidated damages. There's a 6-year statute of limitations, which means that for any violation, there's a 6-year time period that could be triggered for a lawsuit. There are, and that's just litigation. The state can impose penalties. The Department of Labor can impose penalties for purposes of violations, $500 to $1,000 per violation, and then for $1,000 and $2,000 for every violation thereafter. With that Wage Theft Act, there are now the possibilities of criminal penalties, including jail time under the New Jersey Act. There are significant record-keeping issues that could create violations for failing to keep regulatory. There's an anti-retaliation provision that we'll probably discuss today. And then there's also the possibility of having license suspensions, stop work orders, really issues for compliance that if a business is not in compliance, the Department of Labor can shut you down. So, some of these issues, criminal and stop work orders, tend to be more issues that come up in serious violations or repetitive violations, but they're all within the realm of possibilities legally. So, for our clients as lawyers and CPAs, the potential for serious penalties really exist. And frankly, there's also an attorney's fee shift that would come in play in terms of litigation. So a small violation of even a couple $1,000s could yield, tens of thousands of dollars of liability and costs. Not to mention that if it's the type of problem that covers a group of people who are similarly situated, or there's a common issue, there could be a class or collective action. So if it sounds a bit draconian, it is. The penalties really are very, very significant.
Well, it's New Jersey, right? So the penalties.
Yeah. Perfect together.
Right, exactly. Now, I know a few years ago, the misclassification of employees as independent contractors became a big issue for the Department of Labor. There were companies receiving notices, warnings almost, about misclassifying independent contractors or employees as independent contractors. Has this gotten worse during the pandemic? Has it been more prevalent, less prevalent? What have you seen during the pandemic regarding independent contractors and being classified as employees, or vice versa?
Well, first, I think it's useful to kind of remind everybody that the classification of independent contractors in New Jersey is a big deal. The law presumes that workers are employees. So there's a presumption of, a W-2 employee for somebody who's working. I know that from a tax perspective, there's different kind of standard than a legal perspective for employment. So, under the employment law, New Jersey adopts an ABC test, which really covers if an employer has control over the employee or the work that's being done. The work is done in the usual or customary place, then that person would be considered an an employee, not a contractor. So in order to establish an independent contractor relationship in New Jersey, from an employment perspective, you need to demonstrate absence of control. The work is outside the business, the typical business of the organization, and it's customarily an independent trade, right? So we say, okay, consider your plumber. Does he have a separate standalone business? Now, in the pandemic, there are additional challenges that come up. One is that sometimes businesses, especially after the real economic hit in March and April, where businesses really shut down, there were, shutdown orders in place. Some businesses, were reluctant to bring back employees. So they might have brought them back as a contractor. Well, we can't bring you back as an employee, but we'll bring you back as a contractor. That is a problem because if they came back to doing the same work they did before, they're really an employee. And so that could exacerbate the situation where, businesses were really struggling, so many still are today, to just kind of keep their heads above water, especially hospitality, restaurants, things like that. So, they may be bringing people back as contractors just to make ends meet, especially if they don't know what, in terms of finances and things like that. But those decisions could really have a problem because really they are employees. And it's especially a consideration if that former employee is collecting unemployment and doing work as an independent contractor. That could raise issues of unemployment fraud, really. And so that could be a big issue. And, I'm not suggesting that anybody's intending to do anything unlawfully. I mean, a lot of businesses are really just trying to make ends meet. But the independent contractor classification is not the way to make ends meet.
And, in this gig economy, aren't there some employees who use the independent contractor idea almost as a carrot to the employee to say, well, hire me as a contractor as opposed to an employee. So, you won't have to pay me benefits and so forth. So there seems to be sort of like conflicting forces here where the state wants people classified as employees, but in some cases, the employee themselves is trying to offer the contractor.
Oh, yeah. Very often the employee wants to be the independent contractor because they're taking, there's a tax issue. Right. There's certain taxation involved, as you well know, a number of issues. But just because the employee wants to be treated as the contractor, the law does not, the law doesn't agree. Right. And in fact, emphatically, the law does not agree. And the risks are very high. It's very costly to be to misclassify somebody as an independent contractor.
So what are the consequences if you run afoul of the law, misclassify an employee, or does it sort of depend on the situation?
Well, again, the state of New Jersey, as well as the law in terms of civil litigation, there's a lot of potential exposure. One, in terms of the state can recover, I think it's 5% of the worker's gross earnings as a penalty, as well as it's like a $250 misclassified employee penalty, and up to $1,000 per each worker. So if it's not just one person, but a whole series of people, that could be a big issue. Another issue is liability and exposure to the state for things like unpaid taxes, unpaid temporary disability benefits, risks with respect to paid sick leave and things like that are really, at issue for exposures. Again, that stop workout order and the potential that your license could be at risk. And then on the other side, you have, or as a companion, it's not really on the other side, the risk of civil litigation. If there's any unpaid overtime that an independent contractor might incur if they were, keeping track of overtime, the employer would owe that as well. Plus that, the liquidated damages and things that we talked about earlier. So there's exposure to penalties from the state perspective. If there's any sort of unpaid overtime, that would also be subject to that 200% liquidated damages, attorney's fees, et cetera. So it's a big deal for purposes of liability. And frankly, it's just not worth it.
What about the other category or another category of misclassification, that is exempt versus non-exempt? I remember when I transitioned from one to the other, I had no clue what it meant. I would venture to say that most employees don't know whether they're exempt or non-exempt. Right. But from an employer standpoint, and from the state standpoint, how important is that distinction?
Well, it's important because exempt employees are exempt from the Fair Labor Standards Act, which is a federal law, but New Jersey follows the Fair Labor Standards Act. So to be exempt, you need to be guaranteed a weekly salary of $684. And you need to perform certain duties, and it would be typically, it's the professional exemptions we'd be talking about here. So executive, basically the boss, who is responsible for the direction of two or more people. They hire, they fire, they handle those issues. Or the administrative exemption, somebody who's responsible for kind of a non-manual aspect of the workplace. But, they exercise discretion over matters of significance. So you think about your white-collar exemptions. Those people are exempt. It's not just the salary, but it's the salary plus those duties. When you look at, and the risk there is if somebody is not improperly classified as exempt and they're non-exempt, they're entitled to minimum wage and overtime. So then you get that issue of whether there's a minimum wage an overtime violation, and you know that as well. It may be that an individual previously was exempt. They were salaried, back before February of 2020. They were a salaried employee, and they held those duties that made them exempt. But certain things may have happened in the last year that changed that. One could be that they're no longer salaried in a way that's expected. So the salary is a predetermined rate that you get every week, week in and week out. So if somebody's hours have changed so that they're furloughed, for example, that may alter the salary basis. If now they're working 4 days and they've suffered a change in pay rate and a change in salary, the employer needs to make sure that that new salary is established. Not just that they're paying 80% of the old salary, but their new salary and new duties are negotiated, because otherwise you're violating the salary basis, and that could be an issue. Another area where the pandemic has shown to have raised issues in terms of exemption, non-exemption, is some jobs have changed. So, for example, again, in the hospitality restaurant world, it may be that somebody was a manager. They were responsible for directing the work of two or more people. They were doing, their duties was management or were management. But in certain businesses, you've lost or furloughed employees, and now the manager is also doing non-exempt work, where they may no longer be directing the work of two or more employees, so they may not meet the classification. So it's important to be looking at the issues of whether the employees still meet those tests, because they are important, and the general rule is under the federal law and the state law, you're presumed to be non-exempt, so the employer bears the burden.
You mentioned a couple scenarios related to the pandemic, and that kind of ties into my last question about miscalculation of wages. Have we seen more employee complaints against employers? Because so much of this stuff happened on the fly, where salaries might have been adjusted and perhaps the communication wasn't there. So have we seen more employee complaints against employers because they feel like they're getting shortchanged on their wages?
I don't know that we've seen more complaints at this point. I feel like they're kind of just about to pop. There's been, I think most businesses and employees have felt like they're, drinking from a fire hose. And so there's been lots of issues, and frankly, people are happy to have jobs if they have them. So we have not seen a deluge of wage and hour complaints to date. But that doesn't mean that they're not going to be, on the horizon. As I said, the rule is a 6-year statute of limitations. That's a long time. And so when you're looking at potential issues, they may crop up. And the misclassification issues or miscalculation of issues, sometimes it's just an honest mistake, that raises issues of whether somebody's owed monies for purposes of, miscalculation of wages, or maybe not all time work was included in the paycheck.
Now, we've all been trying to grow accustomed to different schedules, restaurants, office workers, trying to figure out that balance between working from home, working in the office. What is an employer's obligation if they schedule somebody for work and then for either because the person comes in and they're sick, or that maybe there's no work that day, perhaps the rules around a restaurant have changed? What is an employer required to do if they schedule an employee and then they have to send them home for some reason?
Well, New Jersey law requires that, absent another agreement, that the employee would get paid an hour's worth of wages, so that they would be required to get paid an hour's worth of wages. Where I'm seeing bigger risk, frankly, is the failure to capture all the hours worked. The pandemic has, created challenges for employers in terms of making sure that they're capturing their hours work. And this would go for our CPAs on behalf of their own business as well as their clients' businesses. So, when individuals are working remotely, you don't have people walking in the door at 9 a.m. and clocking on necessarily. The flexibility makes it more important to capture that time if somebody's taking 2 or 3 hours out of the day in the middle of the day. Another area is individuals, if they work overtime, even if it's not authorized, they need to be paid. And so, in your business and my business, we may be working till 6 or 7 at night, but our non-exempt staff are going to, their hours, if you're on a 40-hour-a-week basis without overtime, really they shouldn't be working more than that without overtime. And a lot of times people will go the extra mile, and we're very grateful for that, right? So we're grateful when we have an assistant who's going to stay that extra time for us, but we need to pay that person. And, if you have a habit, a bad habit, but a habit that many professionals have of texting their assistant that, geez, I forgot to ask for this. Can you help me find this? They really should be paid for that time. And, the best practice is to say, please put in for that time. Please, do a timekeeping exception and make sure you're paying for that time. It's important because as we've seen, the pennies add to dollars and tens of dollars very quickly.
Right. We've covered a number of specific wage and hour concerns because of the pandemic. Is there anything we haven't discussed yet that is a bit of a concern because so many people are working remotely?
Well, I think there's a difficulty of tracking hours. That's one thing that, we just need to be mindful of. The Federal Department of Labor recognized that back in July and provided some guidance there, talking about flexibility and talking about the need to keep records. New Jersey, again, has pretty strict record-keeping requirements, more stringent than most states and the federal government. And so we need to keep those accurate records. One of the things that we didn't talk about is if you make a mistake, or if you're hearing this podcast and thinking, oh boy, I've got a mistake, there you can correct it. You can correct it, by issuing a retro check. If there's a claim made and you get a demand letter from somebody saying you owe money, you can, in good faith, if it's an honest, good faith mistake, pay that without the payment of liquidated damages, which is part of the law that went into effect in August of 2019. Now, that's not a rule that if I get caught, I'll make my retro. It's it's an honest mistake, and I'll make that correction. But it is an advantage that we have here under the New Jersey law. The other thing is, you need to have reasonable timekeeping systems, requirements. You need to have something. There is no such thing as volunteering in the professional work circumstance. So your assistant can't volunteer to work overtime as a charitable deduction to you or your firm. And comp time, that's another issue, especially for CPAs. You're in the middle of your busy season, although this year it may seem like all seasons are busy seasons, but you have to pay overtime on a work week basis. I think everybody knows that, but it's helpful to hear. So you can't say, oh, nobody really wants to be, what do we care? We'll work in February and March, and then we'll get our vaccines and we'll take, a lot of time off during the summer. It would be nice, I think, but comp time is not recognized, legally. One other thing that you should be aware of, the New Jersey law has pretty strict retaliation provisions. So if somebody makes a complaint about a wage and hour problem, you can't terminate them without raising a potential presumption of retaliation. So if somebody is raising wage and hour issues in terms of a compliance complaint, be mindful that if you terminate them within 90 days, that could raise a presumption of retaliation and potential significant damages and liability there as well.
It's good to know that employers can take some corrective measures in order to fix any, as you put it, honest mistakes.
Absolutely.
Because I would imagine, and I hope I'm not being too naive here, but I would imagine a lot of the mistakes that happen are honest mistakes, especially amongst small business owners who aren't necessarily experienced in tracking hours and all these other rules that you just mentioned. I mean, you're an expert in them. A small business owner probably doesn't have access or resources to someone like you. So it's good to know that somebody can take corrective measures if something goes wrong.
Yeah, absolutely. It's important. I would think you'd really want to think about it and maybe seek some advice because you don't want to have those corrections used against you. So you really, I think if you're making corrections, if it's, something that's a little bit more systemic or just an honest mistake that you didn't realize that you needed to pay somebody for something, you might want to, seek a little bit of advice before you put something in writing because it could be used against you. So it's certainly a valuable tool that's available, but you might want to get a little bit of advice before you put pen to paper.
Well, seeking professional assistance is always a good idea.
Yeah, there you go.
One last question. So all of these things we've just talked about, New Jersey lawmakers are calling for a special commission to study ways that the shift to remote work during the pandemic has affected issues like overtime, worker retention, productivity, and so forth. Any thoughts on that?
Well, I think it's a great idea that they're studying, that issue. I think remote work has changed dramatically in the last year. Before 2020, I would say it was the exception rather than the rule. And now I think people like working remotely. So there's going to be cultural issues and challenges as we return to the office, because people like working in their sweatpants and their commute, which is just a walk down the hall. So that's going to be an issue. Businesses also, some of them are embracing remote work because it reduces the cost of their real estate footprint. So, that's another issue I'm sure that, some of you are dealing with, trying to figure out what are we doing with leaseholds and how to account for those if leases are being given up. So I would say I think it's great that the state is examining those issues. I think it's just as important for the employers and businesses and their accountants and their lawyers to be examining those issues with them, because the real-time examination of remote work and what it means for your organization, for an organization, is important. And a commission on remote work may not yield any meaningful guidance for a year now. Yet some businesses are making these decisions next quarter in terms of, we'd like to have, folks back in the office by June 1, where we're going to have certain remote workforce during that period of time. What is that going to look like? And so I think it's great to have that commission studying that. But employers and businesses that are thinking about remote work should really be thinking about having policies and procedures in place, having a remote work agreement, not an agreement that alters your at-will arrangement, but an agreement that sets forth eligibility. Not everybody can be eligible for remote work. Even in a hospital, a nurse needs to go to work. The admin may not need to go to work in terms of remote work. So you need to kind of determine as an organization whether you're going to allow remote work and who's going to be allowed to work remotely. Put in place and in writing some expectations of those. Here are your hours. You're expected to be available. I mean, work is work, right? Work isn't babysitting or, taking kids to the park. It may be, if you've got flexibility and there's an understanding that somebody between, 2:30 and 3:30 is going to be picking up their kids from work, but that's got to be that understanding, both in terms of, employee-employer friction and compliance. You don't have to pay for time at that. And so it's a good idea to have policies in place and to have a remote work agreement that is terminable. It may be for the first 6 months we want to continue remote work, but ultimately an organization's long-term goal may be to have everybody back in the office because there's collaborative needs. So to maintain that expectation and control is important, both for the employee and the employer. And also I would think from tax perspective, far beyond what I can provide as an employment lawyer, you're looking at what tax laws are is it New York rules or New Jersey rules, or if somebody's moved down to Florida, how are those rules going to apply? I think are essential to kind of think through.
There'll be a lot of rewriting of employee manuals and employer policy over the next 6 months.
Absolutely. Yeah, absolutely. And writing and rewriting, to be honest, Don, there's a lot of, the world changed on a dime last year, and, the new normal will be a new normal, but our employers, our companies, our clients are really, struggling to get this right. And great new things are happening. I mean, it's a very exciting time to be an employer and a lawyer and a tax accountants and CPAs, but it's struggling. I'm not so sure that our clients would be saying, "Oh, this is great," but there are opportunities that are there and that people are seizing on, and we're excited for that.
Right. Well, the genie's out of the bottle in terms of remote work. So I think we have to adjust to kind of the next normal of what work is going to look like. And I say that speaking to you from literally an empty office. A year ago, 30 people in this office, and right now I'm the only person in our office. So, it'll be different than that 6 months from now, hopefully, or a year from now. But yeah, I think we're all going to adjust in a lot of ways to remote work. So I think that about wraps it up. I want to thank you for joining us today. It was incredibly informative. Really appreciate your time, Kathy.
Yeah, I really appreciate this. As I said, I've worked with you and the NJCPA organization and your members, and I think it's an exciting time. It's challenging times, and really, if you've learned nothing from today's podcast from an employment law perspective, compliance matters, and being proactive and kind of making sure you know the rules and you're in a place to guide your client's business and your business really will be pay dividends and really substantially reduce those risks.
Well, thank you very much, Kathy. We really appreciate it.
Yeah, thanks very much.
To learn more about employment law issues and see a schedule of upcoming employment law events, visit njcpa.org/topics/employment law. To learn more about Fisher Phillips, visit fisherphillips.com.